as long as Glynis is okay with this one.
Members, you may be seated.
Let's start again.
From the beginning. Okay, Justice Hennessy, before we took the break there, I was trying to have marked as an exhibit the second compendium, which is the compendium of documents referred to by Miss Gwynneth Jones. And my friends have an electronic copy. We're discussing what it is, and they are all the documents that are referenced in the demonstrative slide deck. I don't actually intend on referring to it during the course of the examination. It was meant for all parties and Your Honor to have a guide should you be looking through it and want to be able to see the documents alongside it.
So what should it be called?
Well, subject to Mr. Schachter's views, I wanted to mark both the deck and the compendium as a numbered exhibit, but if their preference is to wait till the end of the examination, that's fine with me. And we can mark it as a lettered document now.
Are you dividing them into two different documents, the slide deck, the demonstratives, and the compendium?
The slide deck is the demonstratives,
Yes.
and then the compendium is the aid to the slide deck. So
And
if-
those are two different
Yes.
exhibits?
Yes.
All right. So going with respect to the demonstratives, what's your proposal?
I would propose to mark it as an exhibit, and subject to my friends' views, I'm content to mark it as lettered now and numbered at the end, or numbered now if they don't have any concerns.
Right. Does that suit folks? Usually if you say that you're going to deal with all of these demonstratives, and if they have their genesis in the report, it can be a numbered exhibit usually.
Yes, just before we reconvened, council advised that there is one new document in the demonstratives that is unobjectionable to me, but I don't know what Canada's position is on it. And it's slide deck 25.
I don't have a concern about it. Just don't testify about it.
Is this the map?
Yes.
Yeah,
All right. So shall we mark a numbered exhibit now then?
yes, that's
Ni-
fine.
91,
The demonstratives is 91.
March. Yeah, it's titled expert report, but I will add to it that it is the demonstratives. Exhibit 91, thank you.
Thank you. And then the compendium of the documents referred to by Gwynneth Jones in her demonstratives would be 92.
All 5 volumes.
If it's in hard copy, yes.
Isn't it a lettered exhibit if they're already all numbered exhibits? I just can't remember.
There's some documents in that compendium that are from stage
Page
one.
one. Make it a numbered exhibit. So it's volumes 1 to 5. That is exhibit 92. And council, I believe, just to make sure it's on the record, that the expert qualification of Gwynneth Jones is, and the agreement as to admissibility is exhibit 89.
Yes.
Thank you.
Your Honor, Ms. Jones also has in front of her, just for your information, council is aware, a spare laptop. It has no content or data on it other than her reports and the documents she'll be referring to during her examination. We provided,
Just wait, before we get there, have you made her report? Are you planning to make her report an
yes,
exhibit?
we can do that now. Yes.
Any issues, council?
And just to make sure, Your Honor, that you have the right copy, the document that you should have in front of you has two dates. One says December 29th, 2021, and there was subsequent edits reflected in the errata list. The new date is August 8th, 2022, and it should be on the bottom right side of your volume.
Thank you.
8th, 2022.
And is that it for exhibit?
I have two more.
Okay, why don't we do those and then tell me about the
Sure.
laptop if you don't mind?
Yeah, the edits referred to on the same date. You should have in front of you, it says list of edits, 8th of August, 2022. These were the edits prepared by Ms. Jones, mostly typos in footnotes and correcting naming conventions, no substantive changes.
Should that be lettered or numbered?
I would say numbered.
Thank you. Any issues? Thank you. 94, thank you.
And at Ms. Jones' request, the index of documents that she referred to in her report, this was before the JBD was prepared. It just sets out every single document in her report. Is this all documents 8th of August, 2022? And it's helpful because it describes the author, recipient, the details and the date. And they're also cross-referenced by footnote.
Thank you.
So Ms. Jones asked that this be used to identify documents when you're reading her report.
And I will call that the index of documents to the Gwynneth Jones report.
Yes.
Thank you. Exhibit 95.
Probably while we're finishing exhibits, it's worth identifying two more.
Go ahead.
As you may be aware, Your Honor, all of the experts provided their documents to be included in the joint book of documents. Ms. Jones says she can't confirm all made their way there, but she was able to identify at least two from her report that had not made their way into the JBD. So I don't know that we'll be referring to them today, but for completeness, we want to mark them as exhibits so they are included as documents referenced in her report.
All right. There are documents referenced in the report that you may or may not get to today.
The stage 3 report?
I was just repeating
The-
from you.
Sorry, the
There are
documents.
documents referenced in
Yes.
Ms. Jones' report.
Yeah.
That were not included in the JBD.
That's right.
Okay,
So we just want to have them marked so everybody has access to these documents when we're reviewing her report. And I can describe the document.
do you have a question, Madam Registrar?
I
Okay.
can provide you with one. So the first one is from footnote 332 of Ms. Jones' stage 3 report. The document ID is MAGE0122595. It's the letter dated June 12th, 1908.
Thank you.
1908.
Maybe my eyes are not as good as they should be.
Can I see
The
it?
top of the document. You should have it in.
Yeah. Oh, it should be on my laptop is what you're saying? Yeah. These documents are often easier to read in the digital copy. missing documents. And this is the one from 273. No, it's the other one.
Maybe it's 1903, or I can't tell if it's a 3 or 8.
Yeah.
1898.
Just-
Sorry, now we're on a completely different.
It's
page.
1898, yes. 1898. A letter dated June 12th, 1898, from footnote 332.
It looks like it's January 12th.
Also January 1898.
Yeah, there's just some confusion about the footnotes. My friend started off with saying footnote 332. Footnote 332 is indeed McLean to Hogg, January 12th, 1898.
Okay,
But then subsequently, someone mentioned footnote 273, and I think that might have confused things. But we'll probably get to footnote 273 momentarily.
That's right.
and what is the second document then?
It is footnote, it's a document from footnote 273, referenced in the stage 3 report of Miss Jones. The document ID is MAG E01225895.
All right, and it is,
The title of the document on the front, it refers to the claim on Indian claims, case on appeal of Ontario. In the Supreme Court of Canada.
If I can assist my friend at 273, it's noted as Emilius Irving, notice of appeal served on the council and attorneys of record for the Dominion and the province of Quebec on the 5th March, 1895.
and is calling it Exhibit 97 suitable?
Yes.
Just a bit of a chat going on. Council. Are you content if this is Exhibit 97?
Perhaps we could,
Make a letter.
no, if there are, I would suggest we would just have the witness identify them as documents she has found in the source and to confirm that they're the ones that correspond with her footnotes. And
When we get there.
yeah, that would seem to
Happy
make
to do
sense.
that.
All right, why don't we do that? So this is unmarked at the moment.
Sure.
Okay. When you're ready.
So I was speaking of the laptop that's in front of Miss Jones,
Yes,
and we've provided notice to our friends that because this is an electronic trial, we have provided her copies of her documents that she'll be referring to today on the laptop, so she can pull them up and navigate them if she needs to. She wanted to have her documents and her reports and underlying documents available to her should she need them.
right, and council content with that laptop being provided to the witness with her
That's fine.
documents? Thank you very much. Okay.
So I'll turn to Ms. Jones now. We have kind of done things out of order, but I just wanted to confirm, Ms. Jones, that you have complied with Rule 4.1 of the Rules of Civil Procedure in terms of your understanding your duty as an independent expert to the court.
I have.
And this form has been signed and completed and attached to your report.
Yes.
Thank you. Okay, so Your Honor, if it's okay with you, I'll go through her CV briefly, and then once we're done with that, we can mark those that additional document.
Thank you.
Ms. Jones, do you have access to your CV?
I am getting there. Yes.
You also have a hard copy in front of you should you want it.
Yes.
Where would I find it?
It will be in her report at Appendix B, which if you're looking at the PDF, it would be image 183.
Go ahead.
Ms. Jones, can you tell us briefly about your education, starting with, you have 2 master's degree and a bachelor degree?
I do. I have a master's degree in, I'll start with a bachelor's degree from Queen's University. My major was Canadian history and politics. Then I did a master's degree in public administration, also from Queen's University, which included some courses on statistics, demographics, and a historical course. And I have a master's degree in history from York University, in which my focus was 19th century government in Canada.
Thank you. If we can move to your employment history heading on the first page of your CV, it indicates that from September 1995 to present, you've been working as a consultant historian. Can you please explain to us what services you provide in that consulting role?
Most of the contracts have been, as you say, related to historical issues. Most of them have involved researching and preparing a report. Many of them have been done for litigation, not all of them. Some of them have been done to support negotiation processes. And as well, I have completed some contracts which have involved preparing educational presentations on especially Indigenous history. For example, for the Royal Canadian Mounted Police, I did a project for them. But most of them are involved doing extensive original historical research and then preparing a report on the issue before the parties.
And prior to your work as a consultant, I know that you had various positions as a research coordinator, policy advisor, and a researcher working for government. Can you go over that briefly, please?
From 1984 to 1995, I was employed by the province of Ontario. I started out as a land claims researcher in 1984 and took a year's leave of absence to complete my master's degree, and then came back and was appointed the head of research for Ontario Native Affairs, which at that point was the only arm of the provincial government doing historical research on Indigenous issues. So essentially, me and my team were supporting not just the work of Native Affairs, but the work of other ministries in the Ontario government for which historical research was required. I retained that portfolio of essentially managing the research agenda, which was the dedicated research branch of the Ontario Native Affairs Secretariat was redistributed after 1989 with the idea that we could contract out the research if we needed it to be done. So I did continue to have responsibility for managing those contracts, but I also was involved in land claims negotiations, negotiations on lands and natural resources by the Ontario teams, and on intergovernmental discussions, especially on issues relating to Métis and what were then called non-status Indians. And was also working in policy development and in liaison directly with some Ontario First Nation and Métis communities, especially on the north shores of Lakes Huron and Superior.
Thank you. Just for everyone's benefit, do you have any notes in front of you or anything on your laptop prepared independent of the documents entered as exhibits in the court?
No.
Going to your page 9 of your CV. Under other qualifications and special interests, are these the cases in which you've been qualified as an expert witness?
Yes. Now there are, this is a CV from 2021.
Yes.
So there are a couple of others that I can add at this point. I was testified and was cross-examined in a motion for summary judgment in Alberta in February of this year. And just a few weeks ago, I was qualified and testified in a claim before the Specific Claims Tribunal in Saskatoon.
And can you tell us about any other proceedings listed here in particular that you think would have some relevance or connection to the issues that you've researched in this case?
Well, of course, the most salient one is in the first phase of this proceeding. I was qualified as an expert in that proceeding. And also in the federal court, I was qualified as an expert to testify in the Daniels case, which did concern the genesis of the British North America Act, and in particular, the clause 9124, which relates to Indians and lands related to Indians, lands belonging to the Indians.
And I see there is also a reference here to the Southwind case. Can you briefly describe what that case touched on?
The Southwind case was a case involving the construction and management of a dam in northwestern Ontario, which involved the Ontario and Canada governments and a number of different departments, especially within the Government of Canada, in the management and construction of the dam.
What was your involvement?
I was an expert witness in that case.
Qualified?
Yes, that Southwind, I was qualified, I read here, as a historian having expertise with respect to the interpretation of the interaction between the Canadian government and Aboriginal peoples based on
When-
historical records.
When you read or make reference to a document, and it's helpful if you do that, could you let me know where you are?
Certainly.
Go ahead.
That is, I think that is page
Page 9.
9 of my curriculum vitae.
It's image 191 on the stage 3 report.
Okay, I'm just trying to find on page 9.
Okay.
And where will I find it on page 9?
Under other qualifications and special interests.
How many down?
That looks like it's about the third one down in the federal court.
Thank
Federal
you.
court. That's
See it.
right.
Are there any other cases that you wanted to speak to, Ms. Jones?
I don't think there are any in particular. My qualifications have been broadly similar across all of these cases. I don't purport to be an expert in any one particular culture group. My background is not in anthropology or ethnology, although I have done a lot of work on Métis populations. My expertise is really in examining the historical record and in particular the operations of government in the 19th and early 20th centuries. I have a fairly broad and deep base of experience with those documents and in the way the government departments worked at the time, in how decisions were made and how issues were managed and in the individuals involved. So my qualifications tend to refer again to expertise with respect to the interpretation of historical documents or in the administration of issues relating to Indigenous peoples in Canada, rather than any particular qualification as an expert on a particular Indigenous cultural group.
Okay, thank you. And can you tell us briefly, in terms of the parties that have retained you, has it been predominantly government or Indigenous parties with respect to the matters in which you've been qualified?
I have been retained by First Nations, by Métis organizations and groups, by Canada and by the provincial government. My client list.
Any particular provincial government? Are you saying provincial governments or the provincial government? I just missed that.
Ontario.
Thank you.
And probably, I just looked at this last night, and it seems that most of my contracts have been with Métis organizations, actually, and other Indigenous groups, but there is also substantial representation from First Nations and provincial and federal clients as well.
Thank you. If we go to page 7 of your report, under the heading scholarly publications, papers and presentations
Of the report or of the CV?
of the CV.
Thank you.
Ms. Jones, if you could just give us a brief overview. I see that there is some references to attending at various universities in a faculty capacity with respect to legal education. Can you help us understand what that's about?
Yes, I have been invited by often the faculty teaching the course or another guest lecturer to attend and give guest lectures to some of these classes that I've outlined here, often on the role of historical research in litigation or in Indigenous claims, or the role of an expert witness. One item that's missing from this curriculum vitae is earlier this year, at the end of January, I gave a virtual workshop to my colleagues in the Canadian Historical Association on preparing historical reports for litigation. So that one is not on the curriculum vitae from 2021. But this is, I have been invited to either give an overview course on Indigenous history, say key moments or key mileposts in Indigenous history in Canada and the administration of Indian affairs, or to talk specifically about the role of historical evidence in litigation or the role of an expert witness.
I just wanted to ask for everyone's benefit, what is the Historical Association?
The Canadian Historical Association is the professional association of historians, both living in Canada and studying Canadian history. So it's not restricted to people who are studying the history of Canada. It includes anyone who is also working in history in Canada. So that's my professional association. I've been a fairly active participant there since 1985. I've been to many conferences and have, given presentations on my research several times.
Okay, and do you have any training or courses in legal education yourself?
I did, as part of my graduate and undergraduate training, take courses in constitutional law and labor law.
Is there anything else that you feel is important to mention? And if not, then we'll move on.
I think I'm satisfied with that. yeah.
Okay. Thank you, Ms. Jones. Your Honor, those are all my questions on the qualifications. And if you don't have any additional questions, I'd like to have Ms. Jones qualified as an expert pursuant to the qualifications agreement.
Thank you. Council? Very well. Ms. Jones will be qualified as per the agreed qualification statement. You may ask opinion evidence for opinion evidence within those bounds. Thank you.
Thank you. We'll turn up now to the slide deck that you prepared, Ms. Jones. And I don't want to forget, because I promised Your Honor we would mark that item as an exhibit. So maybe we should do the stray document in front of you as an exhibit first. That was the, I've handed it to the clerk. So it was item that was the last footnoted item that I pulled up. Do you have a copy?
It's the Supreme Court of Canada in the matter of an arbitration.
Yes.
Looking for a date.
You should have a copy, Ms. Jones, in front of you.
Right.
Is there a date on? Is there a date on this?
We'll have Ms. Jones refer to it.
Oops.
It's also on the screen.
Well, if you have it, for the purpose of identifying it.
I can help you with that one.
So this is my document. I just located it.
That's right. It's the date listed here is 03/04/1895.
Yeah,
Right.
it's the document title that Mr. Shack read out about.
Right. I just wondered if there was a date.
So
Oh, yeah.
it's, it had a doc ID number of 0182.
The date is 5th March 1895.
95?
Oh, I have it as this is the case on appeal of Ontario. I have a date of April 6th, 1895.
I'll call it 1895. And can you just tell me, is this a decision of the Supreme Court of Canada?
No, this is the case of Ontario at the appeal of an arbitration decision before the Supreme Court.
So is it in the nature of a factum?
Yes,
So this is Ontario's argument before the Supreme Court of Canada?
yes, that's right.
Ontario's filed document.
That's
Mr.
right.
Schachter's on his feet.
Yes, I'm sorry. Is that a different document than what's it? Footnote 273? Because the document footnote 273, which is going to be the new document, is dated 1895.
Right.
Of March 5, 1895. It might be that it's misdescribed and we have to,
Right.
just an explanation.
That March date, I believe, pertains to an agreement by the parties. I dated it in April. If you look at the second last page of the document.
Sorry, we only have electronic copies, just bear with us. Yeah, maybe we can just ask, is the footnote wrong? Or is it a different document? I'm just trying to situate it.
Okay, at
And the
270.
footnote again is 273.
Yes, footnote 273, which was going to be one of the new documents my friend wanted to
Right.
introduce.
73. And that is on page
125.
125. Oh, I think I see what the confusion is here. The footnote refers to a notice of appeal, which is printed in this document. So the notice of appeal is a part of the case on the appeal of Ontario, which is the broader document that we're looking at here. I dated the case on appeal as the 6th of April based on the note of the Secretary of the Board of Arbitrators on the second last page of the case. So the footnote refers to a part of this case.
A part of this document.
Yes. This document contains, the case refers to several different documents, which are reprinted in it. So, but the whole thing forms the case on the part of Ontario.
Did you intend to cite this entire document?
Yes, I cited the entire document because it's the one from which the document that's found in it is drawn.
Can I just ask you again, you have referred to it, and that is the title on the front page, Case on Appeal.
Right.
So is that the best way to refer to this document? Case on Appeal of Ontario?
Yes.
Does that make it helpful for others using this document?
Well, that's very helpful for describing it,
Yes.
but the whole idea was that this was just a document that was supposed to be in the joint book of documents, but now it appears that it's got new information in it. Footnote 273 is part of this document. Now we've got another new document that my friend wants to have
This is not.
entered, unless it's somewhere footnoted somewhere else.
Oh.
I wouldn't mind a copy of, I don't know how many pages is it?
It's 58.
58 pages, maybe a hard copy would be helpful if we're going to be getting into this document.
We
It-
don't intend to get into this document for the purposes of the deck, but there may be parts of the issues that are reflected in that case that will be discussed during the course of the evidence. If I may, Your Honor, Ms. Jones cited to this document in her stage 3 report. There was probably a great effort, as you know, to get all the documents in the JBD. These two were inadvertently not included. They're
I
not
think
being-
the issue Mr. Schachter is making is not whether this document, which I'm going to call the Case on Appeal,
Yeah.
was mistakenly not included in the JBD,
Right.
or whether some portion of it, being the notice of appeal, was supposed to be in the JBD because that was the subject of the footnote. I thought what I heard Ms. Jones say was that the notice of appeal was found within this document.
That's my understanding as well.
Yes,
And that, but this document was not footnoted.
Yes.
Is that
No,
your?
sorry, Your Honor, the entire document was intended and is part of that footnote. It's just the particular document that she's referring to is within the body of that document.
Yeah,
That's not
we're
what
just
she
going to
said.
use names for things, so
Sure.
not this document, that document. So what was footnoted was a notice of appeal.
Right.
What is before me is not the notice of appeal. What Ms. Jones identifies is that the notice of appeal is found within something called the case on appeal.
Yes.
And what I understand Mr. Schachter saying is that the case on appeal was not referred to in the footnote.
That's right.
Would be a new document. So he just wants to see it,
Sure.
that it's not already in the
JBD.
material by reference.
Sure.
And by putting it in today, you're possibly introducing a new document. Maybe Mr. Boggy's going to help you, Mr. Schachter.
Yeah, I mean, my friend indicated that she didn't intend to put any part of this document to the witness, perhaps other than the notice of appeal, but that I kind of gathered that maybe there's something in the other part of the document that we'll hear about in argument. I don't want to hear about that the first time. I mean, like, if it's, if it's relevant to the case and I'm seeing the document for the first time today, that causes a problem to me.
Your Honor, I'm content to have that marked after the break because it's also the case and we can confirm that sometimes documents were not included because there were other documents that may have been similar. So we can clarify that. But Ms. Jones can speak for herself. There are many footnotes that she has referred to where there is a document within document. So this is not unusual in that regard.
Right, and so perhaps at the break, if the notice of appeal, which was footnoted,
Yes.
is findable and extractable, maybe that's the best exhibit to make.
I will have discussions with my friend during the break.
Very good. Okay,
So Your Honor, it may be helpful to have the stage 3 report handy and then the trial demonstratives.
exhibit 93 and 91. Thank you.
And I don't know if it's necessary to mark it today. It's already in the JBD. The stage 1 report is also referred to in the slide demonstratives. And I understand that was exhibit 10 in the first phase and tab 2100 of the JBD.
And when you say the stage 1 report, Ms. Jones, stage 1 report?
That's right.
All right, I don't have it before me, but we could get that at the break. Do I need it right now?
I can give you a hard copy.
Are you going to start with it? Because I see it's 11:30. Is that where you're going to start
Yes.
in your examination?
Yes. Missing report, just 1 moment, please.
I'm going to try and access my own.
Early. I am in Your Honor's hands. I had thought that because we had sort of a late start, we'd probably break around 12.
12 for
Uh,
break,
Yes,
and then
go again till another, I don't know what time people would prefer lunch, 1:30 or 1.
I think that was the question. Given what we know when we started, how do you see the day going?
Well, it's also a shorter day today, right? 3:30?
yeah. 3.
Well, if I was starting from the slide deck now, I would have expected to go about an hour.
All right.
which would bring us to 12:30.
All right.
So
What do you say, Helen?
if others need breaks before, then I'm happy to break it up.
You're good? Can we do it an hour? Let's go. Thank you.
Ms. Jones, do you have the trial demonstratives in front of you?
Yes,
And can you confirm you prepared these demonstratives?
yes,
They're your own?
yes.
And can you tell us, generally speaking, the approach you took to preparing the deck?
It was an interesting exercise, actually, to try to further distill the material that's in my report into a narrative supported by these slides and specific documents to be presented in a courtroom. I haven't done that before, but actually I found it was a very good exercise. It was very challenging, but it really helped to focus the points of the narrative.
I wondered if the witnesses were thinking it was an offloading of the preparations of examination in chief, but it's taken on a life of its own in this trial. So
Yeah.
see how it goes.
I was a tremendous amount of work. It was much more work than I expected. But it did help to try to, well, to condense the main points onto something that would fit onto a slide. And I was trying not to have too many slides. So we'll see whether that worked out. But I was working with both my phase 1 and phase 2 reports.
Do you mean phase 3?
Yes, phase 3. This is only my second phase. Yeah, it was a very interesting exercise.
Thank you.
Okay, and can Justin, before we go in at the start of your deck to the overview, I see that on each of the pages you made reference to your phase 1 report and your phase 3 report page numbers.
Yes,
As well as JBD numbers.
right.
And that's essentially finding reference marks to the spots in your report and the
Yes.
relevant documents. Is
Now
that
you'll
right?
see on about the first 10 slides or so that we have references to the phase 1 or phase 3 reports or the phase 1 or the phase 3 joint book. After about the first dozen slides, there are no more references to things that were just in the phase 1 joint book. So all of the references to the joint book are from phase 3.
Thank you. I'm just going to check one thing. Council, you said that the phase 1 report was exhibit 10
That's what I'm told.
in this trial.
Stage 1.
10.1.
Yes.
Okay.
This is what.
Oh.
No, no. 10.1.
10.1. Let's try it.
And it's tab 22100 of the stage 3 JBD.
Go ahead.
Okay. Ms. Jones, for the benefit of everybody referring to your deck, if you forget, I will try to remember, we want to refer to the slide number so we can keep everybody on track following your evidence.
Right.
Okay, so why don't we start with the slide 2, which is the overview. And if I understand it right, this is just basically the relevant topics listed in your deck that you will cover.
That's right. This is like a table of contents. So each of the headings you see here will be headings on the slides. And within those headings on the slides, sometimes I'll have 2, 3, 5 slides that all have the same heading. But that's the way that I have broken up this material, just to try to group it by a broad subject.
And do the topics generally track your report?
Yes.
Okay, can we go to slide 6, please?
Before I forget, council, you can just make a note of it. You asked Ms. Jones about copyright.
Yes.
For you.
Yes, I will. I will do that now. Ms. Jones, we've already marked your report as an exhibit. Other experts have been asked, and we're asking you whether you're content to prepare your waive your copyright to your report.
Yes.
Thank you.
Thank you very much.
So we're at the slide 6, which is your letter of instruction.
Yes.
And it's dated September 20th, 2021. So you've included this here. Can you tell us generally about the format of your opinion?
The format of my opinion, and there is a page in my expert report right at the very beginning, the phase 3 report, which,
Page 4, I believe.
yes, which does explain how what's in this report conforms, in my view, to the direction set out under the court rules. Historical reports are a little different in format from many of the other types of expert reports that are submitted for litigation, such as reports of evaluators or forensic accountants or geologists or what have you. So I've tried to make it as clear as I can how this historical narrative meets the requirement of the court rules. For example, in item number 4, or the item number 5, referring to the experts' opinions, I do have summary paragraphs within the report and upfront in the executive summary, which will condense and summarize my view of the narrative. But also, I think in a historical report, my expert opinion is contained within the narrative itself, in that in order to write this report, I would have seen thousands of documents. I made a selection according to my understanding of what I believe the key relevant documents would be based on the issues before the court. I also have been trying to present what I feel is a fair and balanced assessment of the evidence, which is available. In other words, I have not begun with the idea of constructing a specific opinion, but to try to portray what is available and accessible today in the historical evidence, some of which is contradictory, some of which is very incomplete. But it is a part, I think, of a fair presentation of what is available to us today as an evidentiary record.
Thank you. From slides 6 to 9, can you confirm that those were the issues that you were asked to review in preparing your report?
Yes.
Okay. And do you believe that your report is responsive to the questions asked of you by Counsel for Ontario?
Yes.
You can go on to slide 10. You've included the slide about your research methodology. Can you take us through that, please?
I have been researching this specific issue for many years now. My research on the arbitrations actually commenced when I was still employed by the Ontario government. That was in 1987 and 1988. And to some extent carried over into 1989, even when I was supervising the research. So what I was doing at that time was going to the Ontario Archives and Library and Archives Canada and collecting documentation relevant to these arbitrations, which at that point were not really very well understood. In fact, many of the documents produced by Ontario in the joint book are ones that I collected in that time period. So I also undertook additional research on the Robinson Treaty and arbitration issues at the Archives of Ontario and Library and Archives Canada in 2014 while I was preparing my expert report for phase 1. I did have access to the databases of documents that are previously exchanged by the parties, but as much as possible, I try to only use those perhaps as a starting point or as cues for places to look for the documentation, because I like to see the documentation in its original context, in the original file arrangement, and in the overall files in which it's located, partly to see whether I would make a different selection of documents, but also to understand more about the context of the documents, which we don't get when we just see them individually selected in a database, to see the kind of information that's preserved, any surrounding information about the individuals or the institutions that were creating the documents that might be relevant to its interpretation. For example, sometimes if there are pages of notes, I'm thinking particularly of the Irving papers, which can be somewhat inscrutable the way that they're organized. There will be files of notes and scraps of documents that were used by Mr. Irving, Counsel for Ontario. If I can look at them in their original file, I can sometimes begin to date and link them to other documents in his collection, where if you just see them on their own in a database like this, there's really very little contextual information as to what they mean or what they relate to or how they were created. So that's an example of the kind of work that I like to do in this litigation.
Can we go to the next slide, 11?
Now, the research for this particular phase was, shall we say, complicated by certain events in 2020 and 2021. And I did want to do some additional research apart from the documents that had already been collected, but the public archives were closed or open to such a limited extent that it would not have been possible for me to attend there and collect the kind of materials that I wanted to collect. So we ended up doing essentially research by requesting complete copies of certain files. I did receive, for example, a number of complete sections of the Irving papers. The Archives of Ontario reproduced their microfilm for me digitally so that I could get access to those. There were some motions for production of documents that from Canada. There were researchers on site in Ottawa who attempted again to obtain some copies of materials to which I wanted access. But again, even the reproduction services at Library and Archives were not fully open during much of this time. So in a perfect world, there were probably other things that I would like to have looked at, but I think we did the best that was possible during that time. There's always, if you're a historian, there are always more things to be looked at, but at some point you just have to work with what you have.
You mentioned the motion for documents from Canada. Did you receive the documents you were looking for?
Not everything, but we did receive some things, yes.
Ms. Evans is on her feet.
Your Honor, you may recall having heard that motion. The motion, Canada produced everything it was ordered to produce, and I just don't want there to be any misunderstanding about that.
Okay, and the last point on slide 11.
Yes. Now you may notice that one of the things that is a little bit different about my report is that I don't refer to very much secondary literature. It's not that I'm not familiar with the secondary literature or that I never use it. But as much as possible, I try to base these reports on the original archival record. Although there are many eminent historians working in the field, possibly not in the field of this specific arbitration history, but there are many eminent historians who have produced a lot of good work, but I'm the only one that's in the courtroom and who can answer questions about what the evidentiary record looks like. So I try as much as possible to base my reports on that evidentiary record so that I can try to give an accurate portrayal of it.
Thank you. I note at, speaking of your methodology, that at pages 179 to 189 of your stage 3 report, you provide commentary on Professor Mesamore's report.
Yes.
Can you speak to the difference between what you observed as your approach versus Mrs. Mesamore's, Professor Mesamore's? We're looking at pages 179 to 181 of the stage 3 report.
I think there are a couple of differences, and I'm just speaking very broadly here between my report and hers. My research for the last many decades has been focused on Indigenous issues and the administration of government administration as it relates to Indigenous peoples. So that is really the depth of my knowledge and expertise. Dr. Mesamore's expertise, I think, lies in a somewhat different area. So there may be a difference between our reports there in that I tend to, I think, provide more background that relates directly to the administration and policies regarding Indigenous affairs in the 19th and early 20th centuries. And I did rely again on my own original research in the primary sources to a greater extent, I think, than she did. In particular, she has relied on the compilations of documents that were prepared for previous rounds of litigation or arbitration on these issues, where when possible, I wanted to go back to the original files. Now, there are documents in those compilations which are not available anymore in their original files. So that I have used these compilations as well. The compilations provide often more legible copies, so I'm not completely against them, but particularly in the records related to Indian affairs, I think I have benefited from having more depth of experience and understanding in those records possibly than Dr. Mesamore.
Thank you. We'll go to slide 12.
So
Sorry.
I'm not sure what the purpose of that evidence was. You did a better job? Is that what you're saying?
Well, I'm not going to be the person who will be the judge of that.
But is that what the question was meant to elicit? That you, I wasn't sure what that was.
Your Honor, we were speaking of the methodology, and she has comments in her stage 3 report, and in points she's indicated in her methodology on her slides also relate to the critique of Professor Mesamore's report, which is what she was speaking to in terms of the approach.
Okay, well, maybe you can point to me comments on the critique of Dr. Mesamore's report. I just didn't hear it in the evidence.
Gwynneth, if you're comfortable, or I can take you to the page if you'd like me to.
Sure.
It That's again at pages 179 to 181. It might be a great starting place to look at page 180, where you're speaking about the difference in the backgrounds. Does that assist with the evidence you just gave?
Yes,
Would you mind maybe for her honor's benefit to review that?
I think if you compare the sections of my report that pertain, for example, to the development of the British North America Act in 1864 through to 1867, you'll see that my report draws on what primary sources are available to us, covering that time period and the origin of some of the clauses in the British North America Act. Dr. Messamore also refers to some of those primary sources, but her narrative draws to a much greater extent on the secondary sources in discussing pre and post Confederation finance. That's a difference between us.
Can you scroll down?
Is that a critique?
Well, I believe in what I do. And
I
I'm sure
just
she
want- I've always
believes in
been
what she
intrigued.
does.
Yeah. like-
Yeah.
In your opinion, is that the way to do it?
I think personally, it's more helpful to have a perspective from someone who has engaged with the primary documents and describes them from firsthand experience in this particular context and litigation.
If we can just scroll up a bit to the bottom of page 180, that's the beginning of that next paragraph.
Now, again, I'm not saying that one needs to say disregard Dr. Messamore's report and only rely on mine, because I think all of the historical reports that have been submitted complement each other in various ways. It's not a question of having to choose one or the other, but if I'm trying to describe what's different about my report as compared to hers, my report, I think, engages more with the history of the genesis of the Section 9124 in the British North America Act, which has to do with Indians and lands reserved for the Indians. And Dr. Messamore's report engages more perhaps with Section 109. And I do think that more emphasis on 9124 is important, because the parties at the time in the 19th century, when they were trying to engage with some of the same issues that we're engaging with today, relied on Section 9124 as part of their analysis. So I have a tendency, again, this reflects my background, to possibly provide more information or perspective about the actions, the jurisdiction, the administration of, and the exercise of the jurisdiction by Canada under 9124 in my report.
Thank you. And then I don't know that it provides any new ideas, but we'll scroll down to the summary there. And maybe you can finish off with the comments in Ms. Moore's report there.
Right. And again, I think this reflects my own background and experience in historical research, that in my report, you may find more information regarding the administration of and the intergovernmental actions related specifically to the Robinson treaties in the Department of Indian Affairs. And as well, I think I can contribute some additional material directly related to the compilation and the approval of the accounts related to the province of Canada, both in the 1870 and in the 1890s arbitrations and litigation processes.
So before we go into the substance of your report, I just wanted to highlight that we did discuss at the outset that you have made reference to your phase 1 report
Yes.
and some of the documents from that phase. Has that created any new ideas that weren't in your stage 3 report, or can you tell us why you went back to stage 1?
I don't think it's new. I'm just, I guess, because I had already presented this material in phase 1, I didn't repeat it really for the phase 3 report. But I think some of it is relevant in creating a broad narrative, especially about, again, the genesis and intent of Section 9124 in the British North America Act, which I do think is relevant. But I didn't repeat all of the material for the phase 3 report that I had set out in phase 1. So that's why I've gone back to the phase 1 report in these early slides.
But you're satisfied there's sufficient connection with some of the material in your stage 3 report?
Yes.
And for the benefit of everybody in the courtroom, after having heard the historical evidence to date, you did hear the evidence of Professor Coates and Professor Mesamore,
Yes.
and you're satisfied that the content of the slide deck is necessary to review in its entirety for your evidence?
The content of this slide deck? Yes. I tried not to put in too much completely superfluous material.
Okay. So I think, Your Honor, we have about half an hour before we take a break, so we'll get started with slide 12. You have a hard copy if you want it before you, Ms. Jones.
Yes.
Otherwise, it's on the deck, on the slide in front of you. When you're ready.
Okay. So I did, as I say, I just wanted to review some of this material that I did set out in my phase 1 report to provide some context to my discussions of the period leading up to Confederation in the 1860s. So what I'm attempting to do here is to follow a line or a thread from, say, 1750, which is where I've started here, through to the pre-Confederation period in the 1860s. That's the purpose of these first few slides. And I begin in the 18th and early 19th century with the British Crown's relationships with Indigenous people, which were conducted through the imperial officials who were part of a military establishment in British North America, which reflected the Indigenous nations' importance to the British as military allies. And I think we've heard quite a bit of evidence about the Royal Proclamation of 1763, in which the British Crown reserved to itself the exclusive right to purchase lands in British North American territories, quote, reserved to the Indians as their hunting grounds prior to surveyor patent, which is the origin of the treaties in what we call Upper Canada or now Ontario.
Over to
This,
slide 13.
so a milepost that I have identified here is in 1830. This is the Imperial Secretary of State for the colonies. So this is a British cabinet official, is writing to the governor of British North America at that time, who is also, of course, a British government official. And the Secretary of State for the colonies is directing the governor to make a change in the imperial government's policy towards Indigenous people. Whereas previously they had been dealt with and treated as military allies. This marks the beginning of an official shift in policy towards what we call today the civilization policies. Whereas to attempt to change Indigenous people's way of life and religious beliefs, and to encourage them to live essentially more like the European settlers who were occupying the land in the British North America at that time. This was perceived as part of the imperial government's mission. So what is happening in 1830 is that the governor of British North America is being directed to change the Indian Department as it is in place in the several provinces, which means at this time, Nova Scotia, New Brunswick, Prince Edward Island, Upper and Lower Canada, with the governor of each rather than a separate official, which had been under the military branch of the government. The Indian Department was at that time part of the military establishment. So this is a move from the military establishment to the civilian government, essentially, for these purposes, which Mr. Murray describes in the quotation there. But still at this time, all of the expenses of the Indian Department, including the treaty annuities, were paid for by the imperial government. So that goes through the normal parliamentary budget appropriation process in the United Kingdom, with which we're familiar. It is imperial government money, which is paying for all of the expenses of the Indian Department.
Could I just ask you one question? Maybe you said it, but I didn't catch it. How were they changing? How are they moving the Indian Department from military branch to the civil branch? Was that, I'm trying to remember from stage one, was
Right.
that was the military branch run by the imperial government and the civil by the colonial government?
No,
Something
at
like
this
that?
time, they're both still operated by the imperial government. They are
Right.
imperial government branches, officials. So there had been a superintendent of Indian Affairs who was part of the military establishment. What Mr. Murray is directing now is that the governor of each colony, in his civil capacity, in other words, as the imperial official responsible for that colony, is now going to be the person who is in charge of the Indian Department.
And that's the move that takes it out of the military branch?
And over to the civil side.
Thank
But
you.
it's all still part of the imperial government, not the local governments.
Okay, thank you.
Can we turn to slide 14?
So as part of this move to what is called the civilization policy, the the per capita distributions of annuities, which were at that time often in goods because money still had limited circulation in many parts of these colonies, were eliminated to be replaced by a system where each treaty signatory, a nation, would have an account with the Indian Department and would be able to requisition goods from an amount of money, which would have been the total specified under their particular treaty. The idea was that these requisitions could be made for items such as European style housing or livestock or farm equipment, things that were perceived by the imperial authorities as being more suitable and more useful to the mission to say the phrase is to civilize the indigenous peoples with whom these treaties had been signed. Now there's another big shift in 1835 where the money to fund these annuities in Upper Canada, which is all we're talking about at this stage, and under the land cession treaties and not the surrenders of Indian Reserve lands, the money to pay those annuities was drawn from what was called the territorial revenue of Upper Canada. So the imperial government is saying, we don't want anymore to send you money from Britain to pay these annuities. We think that you should pay these annuities from what you call your territorial revenue, which at this time was mostly composed of customs and excise was the largest part of the territorial revenue, and also fees. There are land sales revenues and some other miscellaneous sources. So that comprises what's called the territorial revenue of Upper Canada. And again, this is before the Union, so it's before the creation of the United Province of Canada. But all of the rest of the Indian Department budget, and that includes for salaries, the administrative overhead, and what's called the present distributions, which are the ceremonial distributions of goods to commemorate the relationship between Britain and its Indigenous allies. All of those were still paid for by the imperial government under the parliamentary budget appropriation. But the annuities to pay for the land cession treaties after 1835 were to be drawn from what's called the territorial revenue.
Can we move to slide 15?
I put in this slide partly as a way of explaining why the imperial government felt that it should continue to be responsible at this stage for the Indian Department, why it wasn't transferred to the local governments. This quote, which has been used many times, is indicative of a very influential attitude at the time for the members of parliament in the United Kingdom who were making these decisions. This is from a House of Commons committee on the Aborigines of the British settlements. So this is a parliamentary committee in Great Britain that issued a report in 1837. And their recommendation, among their recommendations, was that, quote, the protection of the Aborigines should be considered as a duty peculiarly belonging and appropriate to the executive government as administered either in this country or by the governors of the respective colonies. So again, remember the governor is an imperial official at this time. He is not locally elected or appointed. And the quote goes on to give the reasons why they believe that it's not a good idea to have responsibility for Indigenous affairs managed by a local legislature. That those local legislatures are responsible to and in part comprised of settlers who have, as the quote says, disputes to adjust with the native tribes or claims to urge against them, so that the representative body would be a party in those disputes and therefore ought not to be the judge. And I think this part of this attitude, well, it explains, I think, for one reason, why the imperial government retained responsibility for Indigenous peoples alone out of all of the other colonial responsibilities until 1860. And to some extent, it will inform the attitude that saw the central government in Canada assume responsibility for Indigenous peoples in 1867, that there should be some separation between, I guess, the local and the central, or the local disputes, and a more senior government that is not driven so much by local disputes,
Or is in fact what this quote is saying,
Yeah.
is not a party to the local.
is not a party to the local disputes.
Is-
Yeah.
Do you agree with that reading of it?
Yes. So that's just a little bit of a foreshadowing as to what will go on later.
We can turn to slide 16.
These are some other mileposts, which I think will be familiar to us by now. The Union of Upper and Lower Canada into the United Province in 1841. There is no change to the administration of Indian Affairs. In 1844, the secretary to the Governor General, who's called the Civil Secretary, who goes with the Governor General. He is also an imperial official appointed in England and usually comes from England, is assigned to be the Superintendent General of Indian Affairs. So it's not the governor anymore, but it's his second in command, who at that time is called the Civil Secretary. And in 1847, we have the imperial assent to Province of Canada legislation, which transferred control of all Province of Canada, as we call it, territorial and other revenues. So again, this includes not just revenues from the land, but revenues from a variety of sources, into a consolidated revenue fund under the control of the elected legislature. That's what's different about it. There had been shifting arrangements over time, but at this time, remember that the imperial appointed governors were still very active participants in the politics of these legislatures. It's not the way it is today, where he was simply a figurehead. He is quite actively involved in forming governments, in building alliances among the elected representatives, in directing policies, and there is still a reserve of money that the local legislatures don't have under their control, which are under the direct control of the governor. So this is an important milepost in responsible government, in that all of the revenues were transferred to the control of the legislature, the elected legislature, but on the condition that the legislature grant back a defined amount of money, which is given in the legislation, to the Crown representative to cover expenses such as the salaries of judges, the expenses of the civil service, and the annuities payable under the Indian treaties. And that list of itemized expenditures, which are essentially guaranteed and are the legislature has agreed to commit will be fulfilled every year. That is called the civil list.
You can go to-
So these line items would no longer be subject to an annual vote in the legislature. They are guaranteed.
Move to slide 17.
But the imperial government at this time was also making it increasingly clear that the imperial government did not wish to continue funding the colonies. And while they still retained the responsibility for managing Indigenous affairs, the imperial responsibility for funding the Indian Department was being gradually narrowed. But by the time the Robinson treaties were signed, the province of Canada was under notice that the imperial government was going to discontinue the funding for the presents to Indigenous people in Upper and Lower Canada. And by the mid 1850s, the imperial government had also provided notice that it intended to transfer all the financial administrative responsibility for the Indian Department to the province of Canada. I mean, there are a number of course, there are many other things going on at this time. Britain is involved in a very expensive war in the Crimea, which is draining a lot of its resources. And as well, there has been the Irish famine of the late 1840s, which has created a great deal of upheaval and sent a lot of Irish people to the colonies. And the imperial government, I think, was just completely rethinking its role in terms of, in relation to its colonies, to say, we are not in the business anymore of funding our empire, at least the parts of the empire that we believe can be self-sustaining. So with that in mind, the civil secretary, who is the governor's secretary and the head of Indian Affairs de facto, and two other commissioners were given a mandate in 1856 to make some recommendations on how the function of the Indian Department could be funded and carried out based purely on the resources of the province of Canada. And the province of Canada could not fund the present distributions under its existing budget. So the last large-scale distribution took place in 1856.
Before we move to the next slide, Ms. Jones, how did the imperial government plan to fund agreements with Indians, given their shift in and thinking in spending money in the colonies with respect to Indians?
So just before you get to that question, it flows from your comment, Ms. Jones, that the Indian Department was not going to be funded purely based, or could not fund its responsibilities purely on the resources of the province of Canada. Do those responsibilities include both presents and annuities,
Yes.
as far as you understand? Okay, now your question, Ms. Glasser.
So yes, the annuities, as we recall, were already being paid for out of the territorial revenue of the
Mhm.
colony. But the present distributions, which had at one point exceeded the annuities in value quite significantly, were no longer continued after the imperial government stopped funding them.
Thank you.
So does the source of the monies change for the annuities?
Not at this point, no.
Slide 18.
So in 1860, the imperial government makes good on its warning and discontinues funding for Indian Department salaries and other expenses. There is still a very small amount of money coming in for some specific, one might almost say charitable purposes. But this is what the imperial government has been talking about for the last 10 to 15 years, that eventually the colony will have to fund its own Indian department. So in June of 1860, the Imperial Royal Assent was given to a Province of Canada statute that establishes a new framework for the administration of Indian affairs in Canada. So there has to be, if the civil secretary, if the imperial official is no longer going to be the superintendent or the superintendent general of Indian affairs, someone else has to do it. And that person, it was decided, would be the Commissioner of Crown Lands, which was a cabinet post in the legislature of the province of Canada. So that meant for the first time, there is a publicly accountable and elected member of the cabinet responsible for Indian affairs and representing the Indian department at the cabinet table, which had been, of course, the way other government departments had been operating for many years. But the Indian department had always been separate from that. They had always been reported directly to London.
Until this time, until 1860?
Until 1860,
Thank you.
Can we go on to slide 19?
yes. So under this 1860 Act, the Indian Department officials, who in many cases remained the same human beings, were appointed and paid by the Province of Canada government, and they were they became part of the provincial civil service, again, for the first time. A man named William Spragg, who had been the chief clerk in the Department of Crown Lands, became the first Deputy Superintendent General of Indian Affairs. In other words, the deputy minister responsible for Indian affairs. And the Indian trust funds, which are mostly composed of the proceeds from those treaty people who had ceded some of their Indian reserve lands. That money was transferred from transferred to the management of the Crown Lands Department and included within the province's consolidated revenue fund. Again, prior to that, they had been separate because they were controlled essentially by officials of the imperial government.
I'm just going to ask you to slow down. So, because I want to go back to this comment. Prior to that, they had been separate. What had been separate?
The Indian trust funds, which
From
is
the consolidated revenue fund.
yes. So there's an order in council which actually formally transfers those funds to the consolidated revenue fund. But this is the proceeds from Indian reserve land sales, not the treaty annuities. But say in the case of Six Nations is a very good example. They had a substantial amount of money from the sales of their Indian reserve lands. And those prior to 1861 had been separately controlled by imperial appointed officials.
Mr. Schachter's on.
Yes, I noticed we're getting into the incidents of the Six Nations. I don't recall that in any of the reports. We're getting into a new area here.
We're not.
What?
Perhaps you would speak to me,
Yes,
counsel?
my apologies. We're not, we won't be speaking in any detail about the Six Nations.
Oh, okay.
Thank you.
Now, there's one thing that's a little bit different about the Robinson Treaty annuities, because the Robinson Treaty was reached after the creation of the civil list in 1847. Their annuities were voted every year by the provincial legislature, the province of Canada. And also there was a custom in the province of Canada that if money was spent in one section, as they called it,
What's a section, like a department?
it would be officially the names under the province of Canada were Canada East and Canada West.
Oh.
But the old names, Upper and Lower Canada, were so generally used. I've continued to use them because it's what you see in almost all the documents. So, for example, if there was an expenditure in Lower Canada on some project or capital expenditure, administrative expenditure, the custom, it was just a political custom, was that there would be an equal or approximately equal expenditure made in the other part of the province, in Upper Canada, for example. So this was a way of trying to keep together the very fragile political coalitions that were necessary to form a government in the province of Canada at the time, because Upper and Lower Canada had equal numbers of representatives in the legislature. In order to command a majority, a coalition had to get representation from both parts of the province of Canada, Upper and Lower Canada. So this was a convention that grew up over the history of the province of Canada. So when the Robinson treaties were signed and there was an expenditure, therefore, for the annuities every year, a roughly equivalent amount of money was set aside for what were called the Indians of Lower Canada. There was an allocation of land that was crown lands that were made for them. And there was a sum of money set aside in the budget. So both that equivalency provision and the Robinson Treaty annuities had to be voted every year by the legislature, because neither of them had been included in the civil list in 1847.
Before we break, I just want to go back to your first bullet, where you referred to William Sprague.
Yes.
I wondered if you could just help us understand what, if you have an understanding of what the chief clerk of Department of Crown Lands responsibilities were prior to him moving into that new role.
The chief clerk of the Department of Crown Lands, the chief clerks of all these departments were very senior officials. You know, one of the things that they were responsible for was the management of all the correspondence that came in and out of the departments, which effectively gave them a great deal of administrative control over how the business of the department was carried out. So, for example, in the Department of Crown Lands, you might have a surveys branch or a land patents area, or there would be various subdivisions in the Department of Crown Lands, formal or informal. But the chief clerk was the person at the top of that pyramid, essentially dealing with all of the incoming and outgoing business of the department. So he's more than just the person with the biggest desk in the in the typing pool. He's a very senior official.
And did that department at that time have any responsibility with respect to Indians?
It did. The transactions for sales of Indian Reserve lands were undertaken by the Department of Crown Lands. And as well, the surveys were undertaken by Crown Lands surveyors. So there was actually quite a bit of involvement by the Department of Crown Lands in Indian affairs administratively.
Thank you. Your Honor, that completes the first section of the report regarding Crown administrative responsibility for Indigenous peoples. We're going to move on after the break to the Confederation of British North American Colonies. So I thought now would be a good time to break because it's 12:31.
But what should we do for lunch? 12:30. Can we do an hour? Yes, 1:30. That would work. That's all.
All right.
Thank you.
Recess until 1:30.